Welcome to Unwiring Tech, the podcast where we break down the biggest conversations in technology, AI, and society. I'm your host Ranjana, and today we are diving headfirst into one of the most heated debates in artificial intelligence: AI and copyright issues. Generative AI has taken the world by storm. Companies like Microsoft, Adobe, and GitHub are racing to integrate it into their products. Generative AI has taken the world by storm. Companies like Microsoft, Adobe, GitHub are racing to integrate it into their products. Startups are securing eye-popping funding rounds, and socially, AI-generated memes are everywhere. But amid the buzz, there is a legal storm brewing. Let's put things into perspective. OpenAI, the company behind ChatGPT, is in legal trouble in India. ANI, a major news agency, has sued them for allegedly using its content without permission. This case, along with other copyright lawsuits worldwide, could change AI regulations as we know them. To truly understand this debate, we need to first look at how generative AI works. These models analyze vast amount of data that often includes human-created text, music, code, and artwork. Here is where things get messy. Much of this training data is copyrighted material scrapped from the web, usually without explicit permission. For years, it wasn't a big deal. Early AI models were clunky at best, generating blurry images and robotic sounding text. But now, AI generated art is selling online. AI written code is automating developers' tasks. AI generated music is getting eerily close to what professional composers create. And that raises a massive legal and ethical question. If an AI is trained on copyrighted content, is its output legal? Who, if anyone, owns the right to that output? Let's rewind the November 2024 case. ANI filed a lawsuit against OpenAI in Delhi High Court, accusing them of using copyrighted news content to train ChatGPT. ANI claims OpenAI's model have memorized and reproduced their content in user queries, violating copyright laws in India. OpenAI, however, is pushing back. They argue that they don't have a legal presence in India, making them outside the jurisdiction of Indian courts. They also claim that US laws require them to retain training data for ongoing litigation, preventing them from deleting ANI's content outright. The Delhi High Court recently appointed two legal experts, Arul, George Sakaria, and Adarsh Ramanujan, as amicus curiae, or friends of the court, to assist in the case. Their insights are game-changing, but were divided on whether OpenAI's use of ANI's content constitutes copyright infringement. Sakaria suggested that AI training on copyrighted content might not be a violation if the content is used strictly for learning purposes. He pointed out that restricting AI from training on news content could hinder innovation and the public's access to reliable information. On the other side, Ramanujan took a stricter stance, arguing that OpenAI's training process involved the reproduction of copyrighted material, which amounts to infringement. He also questioned OpenAI's opt-out policy, suggesting that it wasn't clear or effective in preventing unauthorized use of ANI's content. One of the biggest unanswered questions is whether AI models permanently store raw data or simply learn patterns from it. If ANI proves OpenAI's model can regenerate news articles verbatim, their case gets a major boost. But the case is more than just ANI versus OpenAI. It has broader implications for the future of AI, journalism, and copyright laws. The impact on AI training. If ANI wins, AI companies may be required to obtain explicit permission from content owners before training their models. They could slow down AI development and raise licensing costs. Second, fair use versus infringement. Courts worldwide are grappling with the question: when does AI-generated content cross the line into copyright infringement? This case could set an important legal precedent for news and AI companies alike. Third, economic consequences. ANI has argued that OpenAI's AI model could threaten traditional news agencies. If AI can summarize news articles without proper attribution, why would users visit ANI website or subscribe to their services? Ramanujan suggested that ANI could suffer financial losses if media houses stopped subscribing and instead relied on AI generated content. Regardless of the verdict, this case will shape the future of AI regulations globally. Should AI companies have unrestricted access to publicly available data, or should content creators have stronger protection? There are two strands of thought. Some experts argue that AI generated work does not infringe copyright because they don't directly copy anything. Others say that generating content in style of specific artist is no different from direct theft. The EU and UK take slightly different approaches, but the debate remains the same. How much human effort is needed before an AI generated work becomes eligible for copyright? If you think AI generated content ownership is complicated, wait until you hear about training data debate. AI models like Stable Diffusion and OpenAI's tools rely on massive datasets scrapped from the internet, datasets that include everything from blog posts to copyrighted artwork. AI companies argue this falls under fair use, a doctrine allowing limited use of copyrighted material without permission. But does it really? Experts say fair use depends on whether AI generated output competes with the original work and whether it transforms the data enough to be considered new. So, is training an AI on Stephen King's novel and generating a new Stephen King book transformative or just plagiarism? We don't know yet. Courts will decide and their rulings could change everything. Let's have a comparative study of AI and copyright laws across the world. Let's begin with European Union. The EU has been at the forefront of regulating AI and intellectual property. The primary law governing copyright in AI-generated works is the Copyright Directive 2019, which aims to modernize and harmonize copyright laws across member states. One of the key debates in the US is whether AI-generated works qualify for copyright protection. Under current laws, copyright is granted only to works created by a natural person. However, the European Commission has proposed the idea of AI authorship, allowing the developer or user of an AI system to own the copyright. The EU has also introduced text and data mining exceptions, which allow AI to use copyrighted material for research purposes. But content creators can opt out of this provision. Another significant development is the proposed Artificial Intelligence Act, which aims to regulate AI system, ensuring transparency and accountability. While not specifically focused on copyright, the AIA may influence future policies on AI-generated content. Now let's talk about US. Across the Atlantic, the United States has taken a different approach. The US Copyright Office and courts have consistently ruled that copyright protection only applies to human authors, affirming that only human-created works qualify for copyright protection. However, the US does not allow broad use of copyrighted materials under its fair use doctrine, which permits certain uses of copyrighted content for research, commentary, and education. AI companies argue that training AI models on publicly available data falls under fair use, but this remains a contentious issue. Recently, a class action lawsuit was filed against Stability AI, MidJourney, and DeviantArt for allegedly using copyrighted images without permission. The outcome of this case could set a precedent for AI copyright disputes in US. Now let's turn to China, which has a unique approach to copyright. Unlike the EU and the US, China has recognized AI-generated works under its copyright law, but with certain restrictions. Chinese courts have ruled that if a human contributes significantly to the creative process, they can claim copyright. But in cases where AI autonomously generates content, ownership remains unclear. China's courts have already dealt with multiple AI copyright cases. For example, Felin versus Baidu, the court ruled that an AI-generated report was not eligible for copyright protection because it lacked human authorship. Tencent versus Shanghai. In this case, the court granted copyright to Tencent for an AI-generated financial report, citing human intervention as a key factor. Additionally, China enforces strict data regulations, meaning AI companies must comply with licensing requirements for training data. This contrasts with the US reliance on fair use. China offers a middle ground, granting copyright if human involvement is significant, but keeping strict control over data use. Now let's talk about India. Copyright laws in India are governed by the Copyright Act of 1957. Traditionally, for a work to be eligible for copyright protection, it must be an original creation of human author. But with AI-generated content becoming increasingly sophisticated, the legal framework faces new challenges. The Parliamentary Standing Committee on Intellectual Property Rights has recommended a review of Copyright Act to consider AI-generated works, but no formal amendments have been made yet. Now let's talk about legal provisions. Section 2D 4th of Copyright Act 1957 and how it impacts AI-generated content. Section 2D 4th of the Copyright Act states that for any computer-generated literary, dramatic, musical, or artistic work, the author is the person who causes the work to be created. This implies that copyright can only be granted to natural person. When this amendment was introduced in 1994, computer-generated works still had substantial human involvement. However, today's generative AI functions autonomously, making authorship a complex issue. Who should be credited as author of AI-generated works? There are multiple possibilities for it. The software developer who designed the AI's algorithm, the user who inputs commands to generate content, or a combination of both, assuming joint authorship. Determining copyright ownership isn't straightforward. AI tools are often trained on massive data sets involving contributions from data providers, developers, and machine operators. The ambiguity in this section leaves questions about who truly causes AI-generated works to be created. Even if joint ownership were considered a potential solution, how could ownership be proportionally allocated? This raises legal complexities rather than resolving disputes. Moreover, the provision assumes only a natural person can create computer-generated content, disregarding the autonomous nature of generative AI. Currently, AI-generated works with substantial human involvement are protected under the Act, but fully autonomous AI works fall outside its scope. This raises a question: should India amend its copyright laws to account for AI-generated works, and if so, what model should be adopted? Countries worldwide are grappling with similar issues. Some propose AI-generated works to be treated as work for hire, with ownership going to the entity deploying the AI. Others suggest a hybrid model recognizing varying degree of human input. As AI continues to evolve, India will need a clear framework to address these questions. Whether the Copyright Act should be amended remains a topic of debate. As lawsuits are piling up, Microsoft, GitHub, and OpenAI are being sued for AI-powered coding assistance. Getty Images has banned AI-generated content and is considering legal action. So what's next? Some experts predict AI companies will move to a licensing model, like how Spotify pays artists for streaming rights. Others foresee stricter regulations on data collection and model training. One thing is certain: the law is struggling to keep pace with AI, and the stakes couldn't be higher. Tweet us your thoughts or drop a comment wherever you are listening. And if you enjoyed this episode, don't forget to subscribe and leave us a review. Until next time, keep questioning, keep exploring, and stay curious. Thank you.